All right, a federal appeals court just did something nobody in that building saw coming. Not the clerks, not the senior staff, not the political appointees who spent the last 3 months constructing what they believed was an airtight appellate strategy. The court didn't hesitate. It didn't schedule extended briefing. It didn't ask for supplemental submissions or signal that it needed more time to evaluate the complexity of the constitutional questions involved. It moved fast. And the order it produced reads less like a procedural ruling and more like an institution deciding it has seen enough. I've been inside this filing since it dropped. The language on page 9 required 4 reads, not because it was dense, because it was surgical. Every word placed exactly where it needed to be to accomplish exactly what the court intended, without giving the appellate strategy anywhere to anchor itself. Here's what the coverage is missing almost entirely. Trump's response didn't come through counsel. It came through the feed. At 11:47 in the morning, on a day when his own Department of Justice was supposed to be reassuring the public that the legal situation was stable and manageable, he posted. And what he posted tells you more about the internal state of this defense than any briefing his lawyers have filed. More on that in a moment. First, the baseline. Pam Bondi came into this role carrying a very specific kind of institutional credibility. She'd been a state attorney general. She understood prosecutorial culture. She understood how departments operate under political pressure while maintaining the appearance of independence. That wasn't incidental to her selection. That was the point. The administration needed someone who could speak the language of legal legitimacy while steering the department's posture in directions that served the administration's political priorities. The federal court system just finished evaluating whether that steering happened. It didn't publish an opinion suggesting it might have. It issued findings saying it did, with internal communications, with documented decision trails, with sealed materials that a judge reviewed, analyzed, and then wrote about in language precise enough to function as a permanent institutional record. And now Bondi's legal team, the people responsible for defending the Department of Justice's conduct in these proceedings, is operating inside a reality they did not prepare for and cannot easily navigate out of. Here's the architecture of how this collapsed. 11 weeks ago, this was a legal fight with defined parameters. State attorneys general making structural claims. A coalition brief that the DOJ's initial legal team assessed as aggressive but manageable. The theory being advanced, that DOJ decision-making reflected predetermined political orientation rather than independent legal judgment, was serious. But it was also the kind of serious that federal courts routinely approach with significant skepticism. Courts don't like inserting themselves into executive branch prosecutorial discretion. The doctrine is old, and it's protective of the executive for good constitutional reasons. The DOJ's initial defense relied on that skepticism. The argument was essentially this: whatever you think about the policy choices this department made, courts don't get to supervise how the executive branch prioritizes cases. That's not a role the judiciary plays. It's not a role the founders designed them to play. Separation of powers isn't a technicality. It's a foundational structural commitment of the constitutional order. That's a real argument. It held for 7 weeks. Then the sealed evidentiary phase produced what it produced. And the real argument met the real record. And the real record was worse than anyone outside that sealed process was prepared for. Because here's what the courts don't do when they review internal executive branch communications and find ambiguity. They don't issue structural injunctions. They don't describe internal strategic discussions as reflecting political outcome orientation rather than legal outcome orientation. They don't write 47-page opinions building a factual edifice brick by documented brick. When a court does those things, it's because what it read wasn't ambiguous. It was clear. And what was clear was not what the DOJ's public posture had been describing. That gap between the public posture and the sealed record is where Bondi's defense crumbled. Not because of legal argument, because of documentation. Now Trump's reaction. Because this is where the story gets structurally significant in a way the cable coverage is treating as noise when it is actually signal. The Post came at 11:47, before the DOJ press office had issued a statement, before counsel had coordinated messaging, before anyone inside the building had apparently been given the chance to run the communication through the review process that's supposed to govern public statements by the executive on live litigation. He called the ruling a disgrace. He called the judge a radical. He described the proceedings as a witch hunt conducted by political operatives using the judicial system as a weapon against his administration. He suggested the appeals court would reverse everything within days, and that the entire legal architecture behind the structural injunction was built on fabricated evidence and partisan hostility. Read that sequence slowly. He called the evidence fabricated. The evidence that a federal judge reviewed under seal. The evidence that the DOJ's own 31-page opposition brief spent exactly 2 pages attempting to contest. The evidence that a former Republican-appointed Solicitor General reviewed and found sufficient to support the core finding when he filed his amicus brief. When your principal publicly describes the factual record as fabricated at the exact moment your legal team's strategy depends on not contesting the facts and instead winning on procedural grounds, that's not a communications problem. That's a strategic collapse happening in public in real time. A conservative Supreme Court litigator with a record that includes arguing on behalf of executive authority in cases that went all the way up. The fabrication claim the president made publicly is the most damaging thing that's happened to this defense since the ruling dropped. You don't describe sealed evidence as fabricated in public when your legal strategy requires you not to contest the factual record directly in court. That's not spin that helps your lawyers. That's noise that follows them into every chamber they walk into for the next 18 months. That last voice. That's not a critic of this administration. That's someone whose professional orientation should be pushing them towards sympathy for the government's position. When they describe the president's public statement as the most damaging development since the ruling, the politics have nothing to do with it. That's a lawyer reading a strategic situation and telling you what the damage assessment looks like from inside. The chaos dimension of this. Because that word, chaos, is appearing in coverage in ways that treat it as political drama rather than institutional consequence. And the distinction matters. Chaos in this context isn't shouting in hallways. It isn't conflict between staff. It isn't the kind of interpersonal disorder that generates compelling cable segments. The chaos that's actually happening is operational. It's procedural. It's happening inside the decision-making processes of a major federal institution that is now operating under judicial oversight, while simultaneously being publicly described by its own principal as the victim of fabricated evidence in a proceeding where the evidentiary record is sealed and supervised. Think about what that means for the career attorneys in the affected divisions. They're making decisions this week about how to approach active cases in the monitored categories. Every decision now comes with a documentation requirement. Every documentation requirement is now being constructed in the awareness that the judge who designed the monitoring framework read the previous internal communications and described what they showed as predetermined political orientation. They're not making decisions the same way they made decisions 6 weeks ago. They can't. The environment changed around them in ways that make the previous operating assumptions unreliable. When the operating assumptions inside a major institution become unreliable simultaneously across multiple divisions, what you get functionally is exactly what the coverage is calling chaos. Except it isn't drama. It's institutional friction generated by the collision between a required new mode of operation and the people, processes, and habits built around the old one. That friction has operational consequences. Cases slow down. Decisions that previously moved through the system efficiently now require documentation and review layers that didn't exist before. Parties in those cases, companies, advocacy organizations, communities, individuals, are waiting longer for resolutions that the system's previous velocity would have produced faster. The friction isn't abstract. It has a cost. And right now, that cost is being distributed across every matter in the affected category, while the appellate process plays out on a timeline that doesn't answer to any of those waiting parties. Now the part that extends beyond Bondi, beyond Trump, beyond this specific moment in this specific proceeding. What the district court did with this ruling is something that will be studied. Not because of the politics around it, because of the legal architecture it constructed. A court that found documented evidence of predetermined outcome orientation in the internal communications of a cabinet-level department, and responded by designing a monitoring framework calibrated to the specific nature of the violation it found. Not too broad, not punitive in form, targeted. Documented, with a review mechanism built in that allows the court to assess whether the compliance is substantive or theatrical. That's careful work. That's a judge who knows this opinion is going to appellate review and wrote it to survive. That's also a judge who knows that future courts evaluating similar claims in similar contexts are going to read this opinion and either build on it or distinguish it. Either way, it becomes the reference point. Every future administration, every future attorney general, every future senior official making decisions about how to approach a category of cases for reasons that run adjacent to the legal merits. They're all going to know that this happened, that a federal court got access to the internal communications, that it read them, that it described what it found in a published opinion that will be cited in briefings, argued in proceedings, and referenced in oversight contexts for as long as federal courts operate in this country. The assumption that the inside of those conversations is invisible to scrutiny was tested here. It failed. The documents came out, the judge read them, the opinion described what they showed. That changed something. Not just for this administration, for every administration that comes after it. Good faith legal leadership has nothing to fear from that change. Good faith legal leadership welcomes documentation requirements precisely because the documentation shows the reasoning was real, the deliberation was genuine, the outcome emerged from the law rather than from the political calendar. The only leadership that fears a paper trail is leadership that needs the paper trail to stay blank. Where does Bondi specifically stand inside all of this right now? The ruling doesn't name her in the operative language. This has been noted repeatedly and somewhat misleadingly in coverage that treats the absence of her name from certain pages as a form of legal protection. It's not. What the footnote on page 29 does is what careful judicial drafting always does when it wants to make a factual connection without extending the ruling's operative reach further than the case requires. It anchors the structural findings to the period of her leadership without making the ruling specifically about her personal conduct in ways that would invite different appellate arguments. That's not protecting her. That's the court doing its job with precision. Her exposure isn't criminal in this moment. It isn't regulatory. It isn't the kind of immediate personal legal jeopardy that generates dramatic headlines. What it is permanent. The factual anchor in footnote 29 of a published federal court opinion is now part of the public record. Every oversight proceeding, every inspector general inquiry, every congressional hearing that touches DOJ conduct in the affected categories going forward now has a judicial reference point, a finding. A description of internal communications that a federal court reviewed and characterized in specific language. That doesn't require criminal exposure to be serious. It's serious by existing. It's serious because it doesn't expire. It's serious because it will be cited by people who had no part in this proceeding in contexts that haven't happened yet, making arguments about patterns of conduct that this ruling helps establish. The personal damage isn't the legal proceeding. The personal damage is the institutional record. And that record is now written. Here's what I want you to sit with before we talk about what comes next. The administration's posture in the days following this ruling has been to project confidence. Official statements emphasizing the strength of the appellate arguments. Background briefings to sympathetic outlets emphasizing the constitutional significance of the separation of powers question. Suggestions that the circuit will move quickly to provide relief and that the structural injunction will look very different after appellate review than it looks today. Some of that confidence may be genuine. The constitutional argument is real. The circuit may find the structural injunction overbroad, even if it doesn't disturb the core factual findings. That's a possible outcome, and ask for full briefing. A circuit that sees the stay petition as legally insufficient on its face will move quickly with limited briefing. The speed and the framing of that initial response will tell you whether this case is about to slow down significantly or accelerate toward an outcome before the 60-day compliance deadline. The compliance conference scheduled for Wednesday. The docket entry after that conference will be visible even if the conference itself isn't public. What it produces, additional submission requirements, scheduling orders, follow-up proceedings, tells you whether the DOJ is engaging the compliance process as a substantive exercise or as a delay mechanism. A judge who has already read the internal communications is not a judge who will be fooled by theatrical compliance. But the conference will show you which approach the department is attempting, whether anyone inside the affected divisions speaks publicly or through background channels about the internal compliance process. 9 months is a long time. Long enough for the friction between nominal and substantive compliance to generate the kind of internal tension that surfaces in reporting. If the documentation requirements are being met in form but not substance, that information has a history of finding its way into public view in institutional settings under this kind of pressure. And whether the fourth sealed matter in the related proceedings becomes visible in connection with this ruling's aftermath. It's been footnoted twice without being named. It sits adjacent to these proceedings, with implications the court has signaled without fully describing. If that connection surfaces, the scope of what we are watching expands significantly, and the timeline we are operating inside becomes less predictable. Here's where everything stands. A federal court issued findings that the United States Department of Justice under Pam Bondi made litigation decisions reflecting predetermined political outcome orientation rather than independent legal judgment. It backed those findings with sealed internal communications that a judge reviewed and described publicly. It imposed 18 months of structural judicial oversight on a defined category of DOJ decision-making. It stayed 3 specific matters. It gave the department 60 days to demonstrate substantive compliance. The president publicly described the evidence as fabricated in the hours after the ruling dropped. His own legal team's filing spent 2 pages on the factual record the president called fabricated. The gap between those 2 positions isn't a communications misalignment. It's a strategic incoherence that every judge and clerk who reads the public record is now aware of. Bondi's name doesn't appear in the operative language. It appears in footnote 29. That footnote is in the public record permanently. It doesn't require a criminal proceeding to do the damage it will do over time. It does that damage by existing in a published federal court opinion that will be cited, argued, and referenced in oversight contexts that haven't happened yet. The legal community outside the political machinery is reading this, ruling the way you read documents that change how things work going forward. The former Republican-appointed Solicitor General filed his brief. The former federal judges are filing theirs. The career attorneys who spent decades inside the institution are on record. Their emerging consensus isn't unanimous, and it isn't without dissent. But its direction is visible. The appellate process has constitutional questions worth taking seriously. The separation of powers argument is real. The proportionality argument is real. The circuit may provide relief on remedy while leaving the core findings untouched. That's a possible outcome. It's not a rescue. Because even a favorable appellate ruling on the scope of the structural injunction doesn't reach footnote 29. It doesn't reach the core factual finding of predetermined orientation. It doesn't erase what the sealed communications showed or what the judge wrote about them. The most favorable appellate outcome the DOJ can achieve narrows the remedy. It doesn't close the record. The record is already written. The internal communications are already described. The finding is already public and permanent. The clock that matters isn't the 60-day compliance window or the emergency stay petition or even the 9-month review hearing. The clock that matters is the one that's been running since a federal judge decided to read what was in those sealed submissions and tell the public exactly what he found. That clock started on Friday. It doesn't stop on appeal. It doesn't stop at the compliance conference. It doesn't stop at the 9-month review or the 18-month monitoring endpoint. It runs through every future proceeding that touches these questions. Every oversight inquiry, every congressional hearing, every adjacent litigation where the pattern of decisions in this period becomes relevant to a claim someone is making about something that hasn't happened yet. That's the permanence of this. Not the injunction, not the monitoring requirements, the record itself. The described finding, the footnote that anchors it to leadership. That's what crumbled on Friday. Not a motion, not a legal theory, not a procedural argument. The assumption that the inside of those meetings was invisible, that the internal communications would stay sealed, that the deliberations, whatever they reflected, would never be read by someone with the authority to describe them publicly in a federal court opinion. That assumption is gone now. Every meeting happening inside that building this week is a different kind of meeting than the ones happening 3 weeks ago. Because the people in those meetings know now what happens when a judge gets access to the record of meetings like theirs. That knowledge changes behavior. Or it should. Or the 9-month review is going to show that it didn't. And the judge who designed the monitoring framework to detect exactly that failure will be sitting across from the compliance record with 18 months of documentation and a very clear sense of what real deliberation looks like. He showed everyone already that he knows the difference. Wednesday is next. September is after that. The 18-month clock is running, and the appeals court hasn't spoken yet. Stay in the documents. Because that's where this is actually happening. Not in the press statements, not in the social media posts, not in the cable coverage that's 3 cycles behind the filings. The story is in the record. It always has been. Subscribe. Notifications on. Because when the circuit moves, it will move without warning. And what it says when it moves will matter in ways that the coverage won't immediately capture. I'll be in the filings. I'll be in the docket entries. I'll be in the footnotes that everyone skips because they're at the bottom of the page and nobody reads to the bottom of the page. That's where this administration's legal reality is actually being written. Not on the feed, not in the briefing room, in the footnotes, in the sealed submissions. In the language a federal judge chose very carefully when he decided the public needed to know exactly what those internal communications showed. He made that choice deliberately. In writing. With 18 months left on the clock, the chaos you're seeing on the surface is just the visible edge of something that runs much deeper into the institutional record than any single news cycle is going to reach. I'll stay in it so you don't have to read 47 pages alone.